Hi, my name is Cynthia. Today I'm here to give you my top 10 tips. I am a retired lawyer and this is my personal opinion. I am not giving legal advice. Let's get started. This topic today is going to be wills. What everybody should have a will, first of all. I don't care how old you are. You should have a will because things happen to everybody. Accidents, you can have an aneurysm, you can fall, hit your head, you can get killed in a car accident, airplane crash, I don't care. Things happen to people. You can get shot in a grocery store. So have a will, I don't care how old you are, because you need to have things taken care of properly. Now if you're married, number two, your spouse will inherit everything. You don't have to have a will. The spouse will get your car. I mean, it's real easy to get that stuff. But even then, sometimes it can be harder to get a house transferred in that person's name if you died. But it can be very easy. If you get a death certificate, your spouse can usually take care of everything properly. So a will is really important to have. But even if you have a wife or a husband, get a will. Next thing, probate. Will has to be probated in a court. And by that I mean filed in what's usually called a probate court. Michigan it's called a probate court. I don't know what your state calls it. But it'll have to be filed there. And by probating means going through that particular system, whatever the court requires. And the person has to do that. The next thing is you have to assign what's called a personal representative. That's what it's called in Michigan. It used to be called executor. Maybe in your state it's what it's called. But that person has to make sure that everything's done properly in your will. And that is the person that files everything with the probate court. You have to get all the paperwork together. So usually it has to be somebody that is pretty astute in that regard. Maybe that person might end up having to hire a lawyer, I don't know, but it's usually not that hard. A person can do it by themselves, but if they're not used to paperwork, they might need to hire a lawyer, and that will entail some money for a lawyer to do it, but in the end, the lawyer will take the money out of the estate for their attorney fees. But again, that's money coming on the estate that if that person can do it by themselves, it's much cheaper down the road. Now that person has to determine your heirs, and hopefully you put that in your will. Be very careful. Put all your kids in the will. And even if you don't want to leave those kids anything, put their name in there. Because in the paragraphs, you're going to have to put something in there. If you don't want that kid to get anything, put that in there. And if you leave that person's name out of there, that leaves an opening for that person to come in and file an objection. They can file an objection anyways, but it makes it a lot easier. They'll claim it was a mistake that you didn't put their name in there. So you don't want to give them any reason to file an objection. So put all your kids' name in there as much as you can to avoid this kind of thing down the road. Next thing. Put all your property in there if you can. Real estate, if you've got checking accounts, you should put those in an addendum attached to your will. And you might need to have very distinctive things set out that way. So put everything you can in their savings accounts, put in your 401k accounts, your anything you have that's got any value to it, put that in an addendum. By the way, you can usually do a will, this is another point, you can usually do a will without a lawyer. A lot of states have you can get on the internet and download a will and fill it out yourself. A lot of states allow you to handwrite it out, and that's even more legal than typing it up and have it notarized in front of a notary. But if you can't do that, then you're going to have to hire a lawyer to do a will. And a will can cost anywhere from $100 to $300. And usually you need more than just a will. You usually need a patient advocate. That's something that will determine what happens to you. If you're in a coma, and can't make decisions for yourself. And the next thing also is a financial advocate. Same thing, if you can't pay your bills, you're in the hospital and you're unconscious and you need your house payment made, rent made, car payment made. Somebody needs to be able to do that, and a financial advocate needs to be set up. So down the road you're going to need all that, and the lawyers can charge you extra for that. But in a lot of states you can download that paperwork and fill it out yourself. Save you a lot of money. So look into it on the internet before you hire a lawyer. And again, if you're not very good on a typewriter or on a computer, you might have to hire a lawyer to do that, and that'll be expensive. Determine who's going to get everything. That's the other thing. And I always suggest to my clients to do a percentage. Don't give a dollar amount in there, because if you do that, the other party might lose out when expenses come out of the estate and there's no money left in the estate anymore. You might lose out on giving them items. So try to give them a percentage of what they can get. Otherwise, you can give them like the house or car or whatever directly, but if you give a dollar amount, it's dangerous to do that. Again, the estate can lose some money, and that person might not get all the money that they need. Then also put in your will your funeral arrangements. Do you want to be buried? Do you want to be cremated? How do you want that handled? And if you got a plot already, let them know that kind of stuff. And put in an attachment to your will, what you want done at the funeral. Do you want a full hearing, a mass, I don't know, a memorial? It can cost money doing that stuff. A mass can cost money, I know that. But if you want a rabbi to do it, the rabbi needs money, so does the priest. So some of that stuff costs money. Make sure you get that money in there. And another part of the will, do you have insurance on your life? That insurance will help pay for that funeral. So that insurance benefit should be, for that benefit, should put the will in the insurance, or for funeral purposes. Put something in there for that purpose, so that that person makes sure that that funeral is paid for. And your debt, and that's another thing, you have to make arrangements to have your debts paid. The personal rep should make sure that your debts are paid. So you need to do something, an attachment, setting out all of your debts so that person knows your debts. Your credit cards, if you have more than one, dental bill you have, I don't know what you have, that you want to make sure gets paid after you pass. So you need to have all that taken care of. Now, that's pretty much what you need on a will. The thing about a will is it's going to be a public record. People will know about it. Unfortunately, some people don't want anybody to know about what they have, but I've had clients tell me that a friend went down to the probate court and found out everything about a neighbor because they were curious about how much that person owned. So if you don't like the idea of being public, you might want to look into a trust, and we'll talk about trust in another video. Again, my name is Cynthia, and I'm a retired lawyer. This is my personal opinion, not legal advice. If you want legal advice, contact a lawyer in your state. But hopefully this has given you some good ideas and tips. And if you did get something out of it, give me a thumbs up. And if you want more information on different topics, subscribe to my channel. Every Monday I'm going to be downloading another topic. Come back again. Bye now.